Hello and welcome to today's live webinar on Demystifying the Digital Personal Data Protection Act 2023. My name is Shagun Dubey and I'll be your host for today's session where we explore different aspects of the Act. Along with us, we have our guest speaker, Mr. Supratim Chakraborty. Thank you so much for joining us today, sir.
Thank you.
Mr. Supratim is a partner in the Corporate and M&A Practice Group of Khaitan Co and co-leads its data privacy and cybersecurity practice. He advises clients on IT laws, including data privacy, intermediary liability, cybersecurity-related issues, and has been providing inputs to the government on upcoming technology-related laws of the country. A member of ASSOCHAM's National Council for FinTech, Digital Assets and Blockchain Technology, and NASSCOM East's Cybersecurity SIG, Mr. Supratim has received multiple recognitions, including IFLR 1000 Notable Practitioner, Legal 500 Leading Individual, Lexology Client's Choice Award for Data Privacy and Protection in India, and Economic Times 40 Under 40 list for India's brightest young business leaders. A very warm welcome to you, sir.
Thanks so much. Thank you.
As we're aware, the Digital Personal Data Protection Act 2023 is intended to provide for the processing of digital personal data in a manner that recognizes both the rights of individuals to protect their personal data and the need to process this personal data for lawful purposes. We'll be taking a closer look at the various aspects of this law and its implications. We'll answer your questions at the end, so please feel free to ask them in the chat box as we go along. So to start off today's session, could you give us a brief on the core ethos of the DPDP Act? And with respect to its application, what led to it being coming up and how does it affect the broader ecosystem of the Indian laws?
Right. So I think when we talk about the core ethos, I think there'll be three things that we should be talking about. One is the right to privacy. But I think a more important aspect here was to do a delicate balancing act. Okay? It is extremely critical, important to protect individuals' personal data. But it is also important to see that innovation, entrepreneurship, and ease of doing business do not suffer. Okay? Especially for a country like India, the stage that we are in, it's very important to keep a focus on this. The third important thing, I would say, is empowering the individuals. You know, globally, across the globe, when you see data protection laws, one of the ethos, one of the reason has been empower the individual so that they have better control over their personal data. I think that is what we wanted to cover through this legislation, and it has been fairly well covered. So that's one. Now, the second part of your question talked about, how probably it plays a role along with other things, other laws that are already present. Okay? And there's some confusion in the market in relation to this, so let's probably demystify that. This law, the Digital Personal Data Protection Act, is supposed to be the mother umbrella legislation for data protection for India. Now, there would be other laws, there'd be sectoral regulations, etc., all that will play a role which, in a way that it will fit into under this mother umbrella legislation. Okay? Ideally, there should not be any conflict, so to say. You know, some people are getting a little mixed up with the provision where it is stating that in case there is a conflict between this law and any other law, then this law will prevail. Then, how do we play out a sectoral situation? I think the thumb rule that people should remember is that this is supposed to be the mother umbrella legislation, and there will be a symbiotic relationship with other regulations which are also talking about data. There is a very feeble chance that there would be a conflict, and in such cases, it has to be seen that if it can be read harmoniously, and that's why we should read this provision a little more carefully and then sort of conclude. I think that will be my initial take.
All right, thank you so much, sir. Another question that arises here is how does the DPDP Act address the key issues such as the grounds for processing of personal data, notice and consent? And talking of consent, we see this new concept of consent managers coming up. With respect to the diverse demography of our country, where does that particular concept lie in?
A good question. I think, whilst it's true that there is a heavy preponderance on consent, But consent cannot be the only ground of processing. Consent is just one of the grounds of processing, if you understand. Now, therefore, we needed to think of more grounds. For example, medical emergency. Okay. The other ground which is worth talking about is, say, for employment purposes. In an employer-employee relationship, often when we used to do internal employee investigation, if you read the Information Technology Act and the Sensitive Personal Data Rules very strictly, you would observe that probably it is hinting towards a fact that you'll have to take a sign-off from that employee whose system you're going to look into when you're doing an investigation. Okay? Therefore, we needed this additional ground, which is employment as a ground of processing, where if it is for safeguarding the employer, say against corporate espionage or protecting the IP of the organization, there the employer need not go and take a sign of a consent for anything and everything under say that head. So these are avenues which had to be baked into this new modern law, and that's what we have done. The other important element in that ground of processing you would be observing is for specified purpose. Now this is very transactional in nature. You know, I love the example that was given in the, I think, the previous version, where it said that you've gone to a restaurant and you are supposed to be, getting in, and they say there is no space. So, sir, ma'am, can you please give your mobile number? I'll call you when the place is ready. Now, suppose you have a situation where the person first takes out a notice and then takes out a consent. You'll be quite annoyed, right? Now, is that really required so long as the purpose is only calling you when the table is ready? Probably the answer is no. You don't need notice and consent. It is for that specified purpose. Now, let me take that same example a little ahead. What if this person who's at the main gate of the restaurant at the end of the day gives that list of people and their mobile number to the marketing guy and says, bombard them with all the offers that restaurant has from tomorrow? Now, that is going beyond that specified purpose for which you had given your mobile number, which is please call me once the table is ready, right? So you should look at it that way. I believe we have done a fairly good job to articulate the other, specify other purposes apart from consent as a ground. Notice and consent, I think we will now move on to a kind of a global gold standard. The notice should contain things like, that we are processing your personal data. What is the purpose of processing? The rights that you have, right to withdraw, right against for grievance redressal, and also that the person can go to the Data Protection Board of India in case there is any complaint, any grievance, right? So all that will be set out, and notices to be given before or at the time of taking consent. Then you have the, again, the global gold standard tenets of consent, where you're saying it should be specific, informed, unconditional, unambiguous. They should, it should be clear affirmative action. So gone are those days of pre-ticked boxes or silence is consent. Just because you have landed up on my website or portal, everything you have accepted, I think those things will change. Okay, we are also thinking of other essential aspects such as the option to withdraw, the option of the individual to access the notice and the consent in English and any of the 8 scheduled language of the Indian Constitution, which is 22 languages. Now, by the way, a lot of people have a lot of concern around, oh my God, it's too much of work, 22 language translation, how do we do that? Let me tell you, I've been observing this market fairly closely. Few things are happening as we speak. As days have passed after this law was rolled out, translation businesses are kind of ramping up their skill set so that they're able to attend to this. Secondly, there are a lot of AI tools which have gotten generated by now, which is almost instantaneously churning out a translation. Now, is that perfect today? Maybe not. But will it be perfect? Yes. Probably with time, we will see that this is getting perfected. And we'll have a solution which is making it inclusive for a large segment of the population and trying to cover our entire ecosystem in India.
So, sir, along with this, could you tell us a little more on the consent managers? Where does that?
Oh yes, so that's a very interesting question, and I'll tell you where this discussion all started, okay? So I traveled across the country when the consultation meet was happening and almost attended all of them. And we realized that is consent a very, very strong ground of processing? Do we need some other sort of support or I would say mechanisms through which we can ensure that consent is really meaningful for everyone? You would observe that we have large illiterate population, people speaking varied languages, even the most educated people are not really reading what they are agreeing or accepting to, right? We're just simply pressing I accept and I agree and going ahead. So what's the mechanism? So a lot of solutions were actually put to the table. I remember one was that should we have a rating or ranking, just like your financial instruments? Should we say that A triple plus rated or something, and that will be a very good organization on whom you can depend and freely give the data. So all that kind of got sidelined, but what really stuck on is the concept of consent manager. Now, not legally speaking, very crudely speaking, what is a consent manager? As an individual, suppose I have a service provider in between who's something which is an entity which will take care of my rights and you know, aspects around my right, okay? I tell that service provider that I'm okay to give my consent for A, B, C, but I'm not okay to give my consent for X, Y, Z. And the job of the consent manager would be to ensure that wherever I'm going, that is meaningfully translated into a proper consent being given. So I think consent manager would actually simplify the consent management process. It will enhance transparency. It will cater to some of the local needs, you know, which we are probably not able to cater today. Facilitate better governance, and it can also promote data literacy going forward, to my mind. It can be that agency which is better explaining things to the data principles.
All right, thank you so much, sir. We've understood how consent is obtained. So the next step would be to understand whom it's given to. So in terms of the Act, could you tell us a bit more on who these data fiduciaries are? And are there any general obligations that they must follow within the Act?
So, good question. Firstly, let me tell you that when these words were getting coined, we were very intrigued, right? World over, an individual is called a data subject. We have called them data principal. World over, a data controller. A data controller is an entity which is determining largely the purpose and means of what has to be done with the personal data. And we have called them data fiduciaries. So clearly you would understand that the intent has been to see that there is a fiduciary relationship, a relationship of trust which is built between the two. It's not transactional. It's not that I have to tick the box that I have to do 5 things, I've done it and I'm good. It's almost like protect the personal data with whatever you can. It's a deeper legal meaning. If you're very interested, you can sort of read up the report which was released, and it gives the footnote also from where it has been taken. But interestingly, what we have to understand therefore is it's much more than just a transactional aspect of a data controller and a data subject. Here, we will, of course, there are a lot of things which are written. I think one is that you have to do lawful processing of personal data, which is at your end or maybe at the end of the data processor who is further processing it on your behalf. Proper consent management, ensuring that there is data accuracy, completeness, data minimization, adopting security measures, ensuring that you report the breaches the way it has been called out in the law, appoint a data protection officer if you're a significant data fiduciary or a similarly placed person, so on and so forth. Largely, I would say a number of things to be done by the data fiduciary, but at the end of the day, if we want to uplift the ecosystem, India to go to the next level, I think these are things that we have to slowly start imbibing and reaching the so-called global gold standard.
All right. So we see that the Act does not categorize data itself, but it categorizes data fiduciary in terms of a significant data fiduciary. So could you tell us a little more on what a significant data fiduciary would be and what its role will be in the Act?
So very interesting, and this is just my personal take I'll start with. You know, I also teach students at times in law colleges and otherwise. And I used to give chit papers to everyone in that classroom, in that session, and say that, can you please write down what is sensitive personal data for you? Almost every time, those elements were different. I may be okay to give my email ID. I may not be okay to give my blood group. But if I kind of say that this is a set answer for everyone, we may not be correct. Okay. So is there another way of looking at it? So I was quite happy, intrigued actually when we saw that there is another type of bifurcation which is happening, which is bringing in significant data fiduciary. Now, significant data fiduciary, in very crude sense again, are the entities which are crunching huge volume and maybe are crunching more sensitive personal data. There is more risk to the rights of data principals. Also, there is potential risk which is associated with much higher than what a normal data fiduciary is doing. What do we need to do in order to ensure that there is better protection as far as this kind of players is concerned? Number one, you need to have a data protection officer who's based out of India. You need to carry out data protection impact assessment and regular audits. You will also have to ensure that independent data auditor is appointed. So I think these are the things through which we are trying to see that entities which are crunching more data, more sensitive data, we are protecting in such situations.
All right, so while data fiduciaries can have internal systems in place, we see that a lot of times these data are processed by data processors. So in terms of that, could you tell us a little more about the outsourcing activities that might be taking place?
Yeah, so I think a good question. One is, yes, a lot of times we see that data is passed on and processed from data fiduciaries end to data processors end. Again, let me give you some simple examples so that our audience understands this in more lucid terms. Okay, suppose I'm an organization and I have a payroll service provider to whom I give a list of my employees, their respective bank account numbers, and the amount that is to be paid. The organization is determining the purpose and means of what has to be done with that personal data. The payroll service provider is simply following the diktat and doing what the controller, the data fiduciary, has told them. Therefore, it's important. The law is putting almost the entire onus on the data fiduciary. It's important that we insulate ourselves better, not only from a contractual perspective, but as we should look at our entire understanding with such data processors. How do we do that? One way to do that is do better due diligence in relation to such entities. You should not be just simply taking on board someone just because maybe there has been an existing relationship. Are you doing deeper diligence on what is the status, what's the cybersecurity coverage? How do they protect data? Have you done some kind of an audit or questioning at least? Okay, so we need to have trusted partners. That's number one. Number two, when you enter into a contractual relationship, you have to understand that writing one line that you will indemnify me for everything will not work in a country like India. You will have to be more creative, thoughtful about what is going into the document. And that could be, you will provide me regular audit reports, or I have the right to audit whenever required. In case there is any breach, you will immediately sort of inform me. Of course, there should be aspects such as indemnity, representations, warranties, covenants. I'm not getting into the legal jargons here, but all that needs to be baked in, along with other thought processes. Do I need, say, holdback of certain amount? Okay, because in a bad day, that entity may not be able to cough up the amount that is involved here. Okay. Do I need to have a bank guarantee involved? Things like those. So we have to be creative about what all we are putting in that document and not simply think that a very flimsy, vague sentence can do. Another suggestion for the audience here is, as we are going ahead and we are going to prepare for this law, you need not really open up the entire agreement that is there with every data processor, right? There is another way of looking at it. Can we go ahead and have an addendum which is talking about data intensely and just negotiate, discuss that with the counterparty and get going? So these are some of the thought processes that I had on the subject.
All right. So with respect to certain categories such as children and persons with disability, does the Act provide for any additional safeguards for them?
Yeah, it does. So I think the way it has been looked into, firstly, the age of child is below up to 18 years, right? Which is fairly high as compared to some of the other jurisdictions. For example, under GDP it is 16 years. Depending on the member state, it can go below up to 13 years. Now, there is an avenue which has been created that in certain circumstances, that age could be lowered. So probably going forward, if there are avenues which are requiring a lowering of the age, that could be considered. But apart from that, what does this particular law talk about when we are considering this delicate element of child's data? Or, so one is verifiable parental consent is one element that has been talked about. The next is no tracking or monitoring of children and no targeted advertisement. Mind you, there are also exceptions possible in relation to both these elements that I talked about. So there could be some things which is actually for the benefit of the child. Possibly we can have exceptions also in certain such circumstances. The third element, which is without any exception is written, is that no processing should be done that is likely to cause detrimental effect to the well-being of the child. So these are the things that are written in the context of children's data and people with disability.
All right. So, sir, with respect to the rights and duties of data principle, what would you like to say in that regard? And what happens in case these duties are not followed?
Yeah, so I think it's a novel concept approach that we have taken. Not many laws on data protection across the globe have the provision where they're also talking about duties of the individuals. It's a two-way process, okay? You cannot only have rights, there has to be certain duties which are to be followed. For example, though frivolous, vexatious grievance process can be started, you should not be impersonating another person, so on and so forth, okay? There is a penalty element which is up to rupees 10,000, which is mentioned in the penalty schedule. Amount is small, but at least the good part is that there's also some repercussion against the duties. If the individual is not following the duties, there is some a mechanism to take action against them.
All right. So, sir, could you explain a little more on the role of the Data Protection Board of India and the penalties an organization might have to face in case of a breach of their duties or a non-compliance?
Right. So I think the Data Protection Board of India, as we all know, it has been spoken about for some time now, is supposed to be largely an adjudicatory body. And if you look at the provision, it talks about individuals also being able to approach the Data Protection Board in case they are not satisfied with, say, a grievance which is being put forth to the data fiduciary. But the good part is that they have said that it has to be a stage-wise process. You have to first see that you have exhausted the remedy as far as going to the data fiduciary is concerned, knocking their door and say, listen, I have this grievance, I have this problem. And if it is not heard or if you're not satisfied, then of course you can go to the Data Protection Board. There is a schedule of penalty which is being talked about, which is there in the Act. For example, if there are security measures which are not taken, as per the Act, then up to 250 crore could be the penalty. If you have not, if it pertains to children's data, it is up to 200 crore. So there is a schedule which has been provided. But the good part is that it is not that every instance that occurs, you hit the highest number. The way it is crafted is that there would be certain mechanisms, some thumb rules which would be applied when determining this penalty, like repetitiveness of the breach, okay, impact of the penalty on the organization, so on and so forth. So there is the safety net which has been created as far as the penalties are concerned, and I think it's a fairly balanced approach. There is no imprisonment provision, by the way, which has been a bit of a scare in the past, but at the same time, monetarily it could pinch organizations. So it is, a nudge to the organizations that we should start moving towards compliance.
All right. So that leads us to my final question. Moving forward, what do you think how can we ensure effective implementation of the DPDP Act?
See, the way I look at it is, let's break this out into 3 bite-sized pieces, okay, so that it's very easy for everyone to understand. The first and foremost one is training, sensitization, and workshop. One size does not fit all, so you will have to see that in this piece, you curate different kind of training and sensitization and workshop for different categories of people that maybe are there in the organization, okay, or even in the larger ecosystem. Just in an institutional construct, let me tell you, what we do usually is for the board level, it will be a 45 minutes to an hour session, largely explaining what we are going to do, the project, the buy-in of the organization, of the leadership, so that even people are required to do a double hatting, triple hatting in certain circumstances, they're allowed to do that. Okay, so that's a first step. Then you could have a 1 to 2 hour session for the mid-management, which is the people who will oversee things, etc. Third one is very critical, which is the people who would be dotting the I's and crossing the T's. You could consider these 2 people to be privacy champions, picked up from every function of the business, say HR, IT, marketing, legal, compliance, all of these. So these people would be your mask bearers going ahead. It is not a one-time process, by the way. So it will continue, right? So you need these people to be educated and excited about it. So these people will go through almost like a half day or a day-long workshop where there is simulation exercises. There are targeted questions pertaining to their area of work. What happens this way is that your ecosystem, your organization becomes mature to understand data privacy protection as a concept and to really give it a meaningful effect. So that's first part. Second is gap analysis, okay, which is where we are today and where do we have to reach. Many organizations follow, say, GDPR or other such laws and say that we are already compliant. But trust me, there is a requirement to actually check to what extent the compliances are being followed, A. B, there is still a bit of delta between those foreign laws and our law. Simple examples could be right to nominate, which is not there probably in many jurisdictions. Age of child we talked about is 18 years, which is fairly different from other jurisdictions. Then you also have other aspects such as when consent managers come into play. This will be different from other jurisdictions. So you'll have to see that are we really bridging that gap and reaching where we have to reach. So this is the second phase, the gap analysis. And the third phase would be plugging of those gaps. Okay, in a structured manner, we then plan out, okay, probably what are the low-hanging fruits. Small wins sometimes give a lot of excitement to the organization, to individuals that, okay, we did it well. Now let's go for the deeper and more complex ones. And that is how you finish the third element, which is plugging of the gaps.
All right. That has been very informative, sir. There are many viewers who are asking us questions in the chat box. I'll try to take as many as possible so that our expert can answer them for you. Firstly, we have Satish Verma asking, how can I protect my data as a data principal?
See, as a data principal, firstly, I think awareness would be the key. We have to understand that, throughout the day, we are going to several places and we are giving our mobile numbers, say, and details, so we have to be firstly cognizant that where all do we want to pass what information, okay? That's number one. Number two is we will have to see that whether in our own ecosystem, whether it is an organization, your child's school, wherever it is, are we spreading the message enough to ensure that overall we become that global gold standard. So I think that will be just a starter from an individual perspective.
All right. Moving forward, we have a lot of questions coming in. So if my data is a part of a data leak, due to which I end up having a lot of financial losses, would I be compensated for it?
Okay, so interesting question. There is an interplay sometimes of multiple laws. Okay, we have to understand one thing, that DPDP Act is not a magic pill for every problem that you have in life. Okay, sometimes you have observed that people start talking about even financial regulatory issues being kind of clubbed along with this, or say child watching certain content on a channel, whether that is also covered. So you have to understand that there is interplay of multiple laws. In this particular instance, if someone say has lost financial, there's been a financial loss because of the data leakage, of course the element that this law would be looking into is the leakage of the data. Okay, where did this happen from? If it's the data fiduciary's end or a data processor which has been engaged by the data fiduciary, the obligation is there on the data fiduciary. A simple example could be, say, a bank which is telling a service provider to print the name and card number, okay, on a debit card or a credit card. And suppose there is a leakage from their end, okay, so the data processor end, that bank would still be responsible. So they should have done better diligence, contractual insulation, like all of that we talked about, right? So this is a quick take on the question.
All right. So, with respect to social media, since a lot of our viewers are very active on social media, could you tell us a little more on the do's or don'ts that people can follow?
Okay, so again, probably we are sort of moving a little away from this particular law, but overall, what we have to understand is that when we are on social media, what all are we sharing there? Okay. Also, some people think that if something is put out on the public domain, it is outside the purview of the DPDP Act, okay, because it is mentioned that if you yourself blogged about something, then that is outside the purview of the DPDP Act. But you have to also remember there is another aspect which you should be careful about, which is the terms and conditions and privacy policy of that particular platform. Okay, so that is something which is also not to be neglected. Overall, as an answer, I would say it is self-restraint and understanding that what can happen if a threat actor, a problem creator, basically is able to pick up all this information. Sometimes these are possible that it could be picked up from several platforms that you are in. You are in Facebook, Instagram, LinkedIn, wherever, okay, I'm just naming. So there could be a situation where someone who's very specifically following you is picking up and making a trail about you, taking all this information. So you need to be very, very sure as to what you are putting up. Definitely don't put up things real time if possible, that where am I headed. I've seen so many times people putting up their child's certificate of school and it has got everything, the school name, the class, child's detail, everything. Is that really required to be put up? You can also do it in a different way. So I think that sensitization needs to come.
Absolutely. So the next question is from PD. Hello. Can you explain more about the consent? Will consent be required every time I need to open a new bank account, or is there any need for use of PAN in every case?
Okay, consent, like we were discussing, is a bit complex, and therefore we have thought of this consent manager concept. Do we need to go and give our consent every time? Consent managers here could play a very crucial role, making it easy for you that not everything every time would be required to be given. Unfortunately, we have not really baked in data portability very specifically here, but anyways, Whatever we have with that, I think we have a decent enough solution to ensure that A, consent is meaningfully given, okay, and it is possible that you could use a consent manager going forward to make it easier for you.
All right. So, sir, another question from Aryan Verma. क्या मुझे अपने ड्राइविंग लाइसेंस रिन्यूअल के टाइम पे कंसेंट देना होगा गवर्नमेंट को?
See, dena hoga, but you have to remember that there are certain other avenues which are there in the law which does not require consent, okay. So, those avenues would still be available as other possibilities for the government to process your data, okay. These are not completely unguarded, but yes, your consent would be required in this particular example that has been cited. And again, this is an inward looking and an outward looking law. So, the government and government agencies would also be required to follow majority of what has been told in this law.
All right, sir. Also, a lot of our viewers are asking more about the notice. So, can you explain a little more?
That's a very good question actually. Sometimes people get very perplexed that, okay, I am going on an app, there is a terms and condition, privacy policy. Now, notice is something which is to be given before or at the time when the consent is being taken. So, what will happen? Practically, probably what will happen is the requirements in relation to notice would have to be baked into those avenues that are available, say on the page of or on the landing page or on the app, which is the terms and conditions and the privacy policy, which will be your privacy notice. And then the consent related language will also come there where you're giving the consent, or some of it could be imbibed into the privacy policy. So, we'll have to, I think, as a ecosystem mature towards baking this properly and meaningfully. At one point in time, actually, when this law was getting debated, there was a thought process that should we have just in time notice being given, okay. So, just like when you're going on the road and it says that turn right, don't turn left, you could actually start designing your apps, websites, etc., in a manner that consent is being given more meaningfully, okay. For example, we were working on an app which is for telehealth, okay, and teleconsultation has a different kind of more meaningful, more granular consent which is required to be taken on. Now, if you see, if someone is getting onboarded into an app for the first time and you have 10 things to be told, the drop rate could increase, right. So, it is not good, say, from a business perspective. But the question to be asked here is, every person who's coming on a telehealth app, is everyone going into teleconsultation with a doctor? Answer is no. So, can we bake that in at that right time when someone is really intending to do a consultation with the doctor? Right. I need not take all the consent right at the beginning. It will be a just in time. I will give more meaningful consent, right? So, I think at a design level, there has to be some rethinking done.
All right. So, the next question is from Praveen. Name of the Act itself is Digital Personal Data Protection. Will the Act also be applicable to physical data?
So, this law per se, and let me give you an example. So, say at the gate when your guard is sitting and taking inputs of all people who are entering and their phone number, etc., that physical register is per se outside the purview of the law. But say someone takes a photograph, a scan of that and puts it into the computer system or network, then this comes within the purview of the law, okay. But do we then consider that, you know, it is completely unguarded, there is no law to really cover a physical scenario, a data scenario? The answer is no. There are laws which are also covering those aspects. This law pertains to digital personal data.
All right. So, sir, our viewers are asking a little more on what the rights of a data principal are. So, I know that we've already covered it, but can you explain a little more?
Yeah, no, so I think, again, important question, because till now we did not have these rights in the way that it is being looked at present, okay. So, there are largely 4 things that you should be mindful of. One is right to access information about the personal data, that, you know, knocking the door of that data fiduciary and asking that what data do you have about me, okay. Next is right to correction and erasure. Third one is right to nominate. And fourth one is right of grievance redressal. So I think largely these are, of course, there are other things which are there, but these are four very important things that are available to the individual as rights under this particular law.
All right. So the next question is by Happiest Minds. Being a global organization, do we need to have a privacy notice in all languages from where we operate? Because in India itself, there are 22 languages.
And a good question. I think I just kind of touched upon it when I was talking earlier on this. The way the law is talking about this is that the individual should have the right to access this in English or any of the 8 scheduled languages, which is the 22 languages. Now, completely understand that this is not a very easy thing for organization. It will entail some effort. But the good part that we are observing is that there are service providers, and some of the AI tools are doing actually fairly good, which are almost instantaneously producing translation into 22 languages. Are they perfect? We'll have to check, okay, because that's something that we have to be careful about. But I think over time, this will be perfected. So we are in that journey. Please understand the reason was more inclusion, okay, so that people can understand this more meaningfully and then give the consent.
Okay, the next question is from Naman. Can my organization delete my historic data set if I ask them to?
Okay, the answer is you have a right to tell them to delete, but there are a few things. If any law, say, just for as an example, asks them to keep that information for a certain period of time, then that will be kept. Okay, so it's not an absolute right. There are certain safety nets also which are built in, and many organizations have this question. I would recommend from an organizational perspective though to think of having a proper policy around data retention. And there are two pieces. The first part of that policy talks about the general principle, ethos, which is to be followed when you think of data retention. The second part would be a little more granular detailing. Okay, HR data, these kind of data, to what extent is it required to be saved, okay, or kept? And then there could be others depending on what all. Sometimes it could be a sector regulated entity where the sector regulator itself has told that, you know, for X time you will have to keep the data. Things like those.
So the next question is from Chris. If any company converting my personal data into digital, then also is consent required?
Interesting question. It has to be seen what is the use case here, okay? If it is understandable that they are taking consent and it will be digitized, then I don't think that probably a specific consent would be required to be understandable. But for the organization, it could be a better move to clearly call it out that this would be digitized and kept in your systems, etc.
All right. So the next question is from Apurva. How shall we adhere to the right to nominate?
A very, very interesting question. I think some organizations are still thinking as to how to really go about implementing it. We'll see how this plays out. But, you know, one of the use case which could be thought of is what we have in, say, banks, just as an example. May not be absolutely correlatable. But yes, that right is available. It is unique to India. And we'll have to see how this plays out. But yeah, this is something that we want to sort of bring in and a nuanced approach as compared to other laws across the globe.
So the next question is from Gamerzone. Why we have to translate it into 22 languages, or can we prepare a notice for our targeted audience itself?
Good question. I think many are actually practically taking some kind of views around that. But like I told you, if you get a more ready solution, which is kind of not so expensive, probably you can look at this solution as well. That, you know, someone at a click of a button gets an access to any of those 22 language translations. Again, I'm telling you, this is not going to be as easy as I'm sort of projecting it. It could be difficult for certain organizations. But this is, again, a move. And the more meaningfully you're able to bring it into play, the better it is. Because world over, please understand, demonstrating compliance is a very big thing. I did not do anything and I was sitting tight is not going to help you. But I tried to do a lot of it and probably we went somewhere wrong a bit, could be taken a little more mildly. So therefore, when I talked about the penalty provisions, what I told is that, listen, 250 crore penalty does not mean anything that goes wrong is 250 crore. There is a mechanism which has been built in to check that, okay, what is the repetitiveness of the breach? What did you do in order to be compliant? Things like those. So if you see those, there are safety nets built in to see that were you actually trying to be compliant.
So the next question is from PD. Does the consent have to be in electric form, or is it allowed to be in physical form, like a signature or a file? And if so, how will the physical consent be managed?
Okay, so the law is per se not calling out anything in this regard. Ideally, I think it should be digital in nature, considering we are looking at digital personal data being under the fold of this law. So probably it will be better that you try and see that you take this in a digital format. There is nothing again specifically called out as to how this has to be taken, but you should be able to keep a track of the consent having been taken at X time, so that in case someone disputes it in future, you are able to defend that, listen, the consent was given at X time, see here's the timestamp, etc. If it is taken in the physical form in an off chance, try and see that is married to the digital information, so that again in a future date, if it is required, you are able to present it.
Okay. So the next question is from Ayush. Will DPDP enjoy extra territorial jurisdiction over foreign companies that deal with data of Indian residents?
So yes, I think actually we should have covered this a little at the beginning. But yeah, so from a applicability perspective, it is akin to many international laws, say GDPR, to a large extent. So if there are foreign entities which are providing goods and services to data principals, individuals in India, then this law would be applicable and they will have to follow the requirements.
All right, so the next question is, sir, could you kindly clarify whether consent for marketing should be obtained specifically for each individual product or at the organization level for entities offering multiple products?
You have to see the use case, okay? It's not one size fits all, but ideally you should take it for marketing and you can cluster the language appropriately, okay? It is better that you are as transparent as possible, and you would know sometimes clustering of similar kind of thing should be okay in order to ensure that you briefly, cogently explain this, say, in a single page, right? Because if you write a very long narrative or take a number of check boxes, probably A, of course, the drop rate will increase and the person who's giving the consent will not give it meaningfully. So it's a very, I would say, a tactful balancing act which you'll have to do. The way you are writing the language will be really the key. And if tomorrow you are tested that you are trying to actually hide something and push something under the carpet, but by writing a very vague statement, you should be able to defend yourself. That see where things are vague and where it is most critical in relation to an individual's personal data, it has been called out clearly.
All right. So the next is from Sarip. With the introduction of the DPDP Act, do the existing IT laws or SPDI rules already stand overridden, or will they be suppressed once the rules are finalized and come into effect?
Yeah, so the IT Act and the Section 43 and sensitive personal data rules, they are still in play. Once this DPDP Act is brought into effect through the notification, and of course this will be after, say, the rules are brought in, etc. It is then that will stand removed, and this will be the law which will be again the mother umbrella legislation for data protection for India. So we will not have this parallel mechanism running under at least a sensitive personal data rules is concerned. Some people have that confusion. Good that this question came up.
All right. So the next question is from Sakshi. At times, it's difficult to identify data fiduciary and data processor in the case of app services. Can you tell us parameters to differentiate between them, or can data processors be data fiduciary as well?
So I think great question. At times we get requests from players who say that, can you just give me a legal opinion stating that I am a data processor and I am out of this law? That is not the way to look at it, okay? what you are actually doing, you need to follow that piece. Now, you could be wearing different hats at different points in time. No problem there, okay? So, the determining factor again is who is determining the purpose and means as to what has to be done with the data. I gave few examples. I'll give you another example, which may be just so that it is easier for everyone to understand. When we are traveling, the travel agent takes our personal data and the airline also takes our personal data. Right. It is almost the same data set perhaps which is getting translated from A to B. But if you look at it, both the airline and the travel agency are determining different purpose and means with our personal data. So what is it that we should be doing? I think one of the fundamental things that we should be doing very clearly, whether it is this scenario like a data controller scenario, it could be a data processor, data controller, processor, so fiduciary processor, all of these combinations could be possible. But in each of these cases, what is critical is that the contract is drawn up very clearly, delineating what are the rights and obligations, what are the fallback options that are there for each of the parties. This part I am responsible for, and this other part you are responsible for. The other angle of this is the outward looking information that you are giving to the individual, okay? So what are you stating? Are you clearly stating that, listen, there are two data fiduciaries which are there in the chain. There is a travel agent, there is an airline, both will get your information, and this is what they would be doing. So you have to be careful that both from an outward looking and inward looking, your documentation is perfect, okay? So in a bad day, you are able to then project that, okay, I told the individual and the individual was fairly clear that this is what is going to happen, this is the processes that is going to happen. Between the two parties, say the airline, and again I'm just picking up that example, the airline and the travel agent, it should be clear that who's responsible for what aspect.
All right. So the next question is from Srivastan. I hope I'm pronouncing that correctly. What will be the legal obligations of a consent manager?
See, again, if you look at it, the consent manager has been put under a lot of responsibility has been put. It's not like, they're free of responsibility and liability. It is almost akin to a data fiduciary, whatever they are supposed to do. Sometimes it has been called out even additionally in some of the sections. So you have to understand that the data fiduciary is actually, this consent manager is actually acting on behalf of the individual. So they have a duty towards that individual and ensure that whatever diktat is being given by the individual, that is being appropriately followed.
All right. The next question is from Happiest Minds. Do we have to carry the legitimate interest assessment for each of the processes, which is in the interest of the organization to process them?
See, it depends on what you get categorized as, what kind of data you are handling, etc. Okay. Considering the organization that it has come from, it should also check that are there in certain of the avenues, are there certain exceptions which are available. Okay. Now, what do we, sorry, can you just repeat the question once?
Do we have to carry the legitimate interest assessment?
So, per se, there is no legitimate interest assessment which is required to be called out, to be carried out as per the law, which has not been called out. But if you are getting considered as a significant data fiduciary, say, data protection impact assessment has to be carried out definitely. You should check that what is the ground of processing that you are following. Are you following consent or some of the other grounds which are available? And probably accordingly you can do an assessment outside of which what has been sort of called out in the law, just to be additionally secure.
Okay. The next question is from Aarti. If the data fiduciary is sharing personal data to the government to be complied legally by sharing death records to the hospital, so in this case, government will be the data processor or joint controller?
Okay, interesting question. See, we have to slice and dice actually. We have to understand the equation better between the several parties which are involved here. If the government is determining purpose and means, then it will be a fiduciary. If it is not, then it could be so that it is in a processor role. Okay, but I would suggest, overall, minus this question also, what I would request all to consider is that right now, before the law is deliberated, say, and we have a lot of judicial precedents which are available, to err on the side of caution and see whether you are determining the purpose and means. In most of the cases we have seen, yes, they are. Okay. Simple example could be that a processor, which was otherwise a processor following the diktat of that particular organization from whom it got the data, is also carrying out their own analytics to figure out how can I better myself. Now, if you look at that kitty, that is actually putting you into the shoes of a data fiduciary. You are determining what is to be done with the data. So, we have to be a little careful and slice and dice and see that what all are we doing with that personal data.
All right. So, the next questions by Learning Mania. Please elaborate on the appropriate technical and security measures that should be implemented by the data fiduciary.
Good question. I think if you look at this particular law, it is talking about reasonable security safeguards to be taken. Okay. Of course, the idea is to keep it flexible for the organization, for the institutions, so that they are able to adopt what is most commensurate to them. Okay. That has been the ethos also. If you observe the drafting of the law, largely the intent has been that the industry should be able to responsibly lap up what has been told as the thumb rules, as the principles, and accordingly play this out.
Okay. So the next questions from Chris. Do we need to consider web-based applications for the privacy stamp, or do only web pages fall under this?
So yeah, it's a little, I think, confusing question, I would say, for me. And maybe we need more detailing around the question. That will be helpful that way. This law is, I'll give you a very thumb rule overarching answer. Wherever there is an element of digital personal data, this law would be applicable. So I don't think that we have a distinction of that sort.
So I have time for just one more question. This is from Vivek. So can you please shed some light on data localization and its compliance in India? I understand that the position has changed from the PDPB 2019.
I think excellent question. I think good question to end with if you are ending with this question. Let's understand that we started with a thought process in the previous version with almost like hard localization. Then we thought of mirroring of data, different categories of data. You would remember there was critical personal data, then sensitive, then normal personal data and all of that, and trying to handle it differently. But over time, I think we observed that what is the best methodology probably for us to be also seen as a global superpower, right? What is the best method that we can adopt? And I think we have taken a fairly decent stance by saying that, okay, data is freely transferable across jurisdictions, but minus few safety nets, few aspects which you have to be mindful of. The first thing is that there could be certain countries which could be called out in the negative list, and transacting in data qua those jurisdictions could be restricted. The second thing is that if there is a stricter law, then that will prevail over the general leeway that has been provided. Simple example could be RBI says that payment systems related data cannot leave the country. So that specific aspect will still prevail over this general leeway. So that is where we are. I think we are trying to again do a balancing act here in order to see that it is a win-win for everyone.
All right. Thank you so much, sir. With that, we conclude today's session. Thank you so much, sir, for giving such an insightful discussion today. So we've covered a wide range of topics from data principle, data fiduciary, and even the role of the Data Protection Board of India. A big thank you to all our audience for joining us today. We hope that today's session was both helpful and informative for you. We will be conducting a lot of further sessions in future, so please stay connected. Hope you have a great day. Thank you.
Thank you so much.